Good afternoon. Attorney Protective would like to welcome you to today's webinar, Checking Out Ethical Considerations for Stepping Away from Your Practice. With that, I would like to introduce your first speaker, Erin.
Great. Thanks so much, Michelle. Well, for many attorneys, especially a solo attorney, the thought of stepping away from your practice for a week or more to take a vacation can be daunting. Instead of creating a healthy work-life balance or proactively trying to avoid burnout, the vacation often seems to increase the stress and pressure an attorney faces. As a result, it often feels easier not to take a vacation. But it doesn't have to be this way. With some advanced planning, it is possible to take and actually enjoy a proper vacation. And hopefully today, Kate and I will give you some tips so you can do just that. Today, we're going to talk about attorney burnout and law firm employment trends, as well as the rules that cover taking a step away from your practice, whether for a vacation or retirement. We'll talk about succession planning, retirement, closing your practice, and then some insurance considerations to closing your practice. So with that, I'm going to hand it over to Kate to talk about our first topic. Kate?
Great. Thanks, Erin. I know I don't have to explain what attorney burnout is. We have all experienced it. Although our jobs can be incredibly fulfilling, being a lawyer is, by nature, stressful and exhausting. From client demands to excessive hours, many overworked lawyers experience burnout and even mental health struggles. The World Health Organization has identified several signs of burnout, including feelings of exhaustion, pulling away mentally from a job, and work-related cynicism. For some of our colleagues, burnout has unfortunately led to substance abuse, depression, and suicide. As shown on the slide, a Bloomberg Law survey shows varying degrees of burnout among attorneys, of course peaking at the end of the year in Q4, but always present and hovering around 50%. Female attorneys show a higher rate of burnout than their male counterparts, and caregivers, whether caring for children or aging parents, are more burnt out than those who do not share those responsibilities. These figures are probably no surprise to the many working parents and lawyers with important responsibilities outside of the office. As lawyers, we are high-achieving individuals who are innately competitive. Qualities like these make us great lawyers, but can also lead to burnout, especially with the many duties and obligations we have besides our jobs. So, how do we identify burnout and try to avoid or remedy it? Take a moment to assess your situation. Are you constantly tired even when getting enough sleep? Are you feeling detached from work and having trouble concentrating once you're there? If you find yourself self-medicating and in a chronic state of stress, you may be closer to burning out than you think. Firms are recognizing this and have tried to accommodate their lawyers. Hybrid work schedules are even more commonplace now post-COVID, and some lawyers work on a part-time basis. Still, a recent 2022 Legal Trends report found that even with certain accommodations, 86% of lawyers work outside the typical 8-to-5 workday, and 73% work outside regular business days. The ABA recently highlighted a New Jersey 2022 survey which showed that 28% of its state lawyers have considered leaving the profession due to burnout or stress. Quite frankly, the work we do is hard and demanding, and these statistics highlight the need to take a break. Erin is going to discuss the importance of vacation and taking that break, along with certain ethical guidelines to keep in mind. But if you do not have a trip on the horizon, remember that you can try to avoid burnout by getting enough sleep, exercising, getting outside when you can, or touching grass, as they say, cultivating hobbies outside of work, and setting boundaries to ensure you can be your best self and best lawyer for your clients. Erin?
Great. Thanks, Kate. Well, Kate talked about attorney burnout, and that's absolutely a real thing. So taking a break every now and then to recharge is really important. And while we cannot shirk our professional responsibilities, we can and we should periodically step away. Your duty as an attorney requires competence, diligence, and proper client communication. These duties can be at risk of compromise during any disengagement from your practice. However, with proper planning, these risks can be avoided. So I'm going to quickly cover the applicable ethics rules and then provide some realistic and hopefully helpful tips for those who are getting the itch to go somewhere warm, especially with winter on the horizon, at least for us on the East Coast, Northeast Coast. So first, let's look at Rule 1.1, which relates to competence. Whether away on vacation or recovering from surgery, lawyers remain accountable to their clients to provide competent representation during any absence. So although you may be enjoying a Mai Tai on the beach, you're still accountable for the legal services for which you were engaged, and you must perform these services competently. Unfortunately, despite adequate planning, some emergencies cannot be anticipated. Therefore, as the best practice tip on your slide states, while unplugging, it may be necessary to maintain some level of contact with your office to ensure this duty is fulfilled. And we will get into this more when we address tips for maximizing your time out of the office. But next, we're going to look at Rule 1.3. So Rule 1.3 of the model rules states that a lawyer shall act with reasonable diligence and promptness in representing a client. Just like the requirement to be competent, a lawyer's duty to remain diligent in the representation is not somehow suspended during vacation or even a short-term absence from the office. In the litigation world in particular, calls or inquiries from the court should be promptly addressed by you or another attorney in your absence who is familiar with the case. Diligence means staying organized in order to meet all deadlines. In other words, not dropping the ball on any client's needs. Being on vacation is not an excuse. You cannot simply check out and ignore deadlines during this time. Finally, under Rule 1.4 of the model rules, lawyers are required to keep the lines of communication with their clients open at all times. They must keep their client reasonably informed about the status of their case and comply with reasonable requests for information. Just like the other ethics rules, an attorney's duty to communicate does not cease to exist because you're on vacation. As an attorney, you are still required to keep a client reasonably informed about significant developments relating to the representation. So failure to communicate with and inattention to the needs of a client may constitute grounds for discipline. Honestly, we all have had experience with some clients that can be a bit more high maintenance than others. So they require more attention and more frequent communication. But much to the chagrin of some clients, you aren't on call at all times to answer their burning legal questions. The reason that I keep emphasizing the word reasonable is because this standard is reasonableness. That being said, by providing a timeline for when your clients can expect to hear from you or someone in your office, you can satisfy this reasonableness standard. But ethically, you cannot cut off all means of communication with them. This is why setting boundaries and tempering client expectations for vacation from the office is so important. You absolutely can enjoy your time away while fulfilling your professional responsibilities, but you may have to do a little pre-vacation planning and strategizing. So let's look at some best practice tips for maximizing your time out of the office. Although completely unplugging may not be possible, there are some pre-vacation strategies you can implement so you can return to the office feeling renewed and refreshed. You want to notify your clients. By letting your clients know you'll be away, you will likely avoid interruption on your trip. Chances are your client will appreciate the fact that you gave them advance notice and respect that boundary. We just discussed Rule 1.4 and how lawyers need to communicate with their clients promptly. So ensuring clients are still getting timely updates on their cases, and if not from you, then from a staff member or a colleague, this is going to be key. You can always suggest that they contact an assistant who can help determine whether something is an emergency or if you can address the matter when you return. It's up to you how much you want to stay connected, if at all, but you'll probably want to include something about your availability when you notify them. Of course, you'll also need to tell your staff, firm partners, and anyone else that you work with that you'll be taking a vacation. Give clear instructions for work that needs to be completed in your absence, contact information for a lawyer providing coverage in your absence, and we're going to talk about vacation buddies in just a minute. But you also want to talk about how to contact you on vacation and when it is and isn't appropriate to do so. Clients may think that something's an emergency when it's not. So make sure your assistant or the attorney covering for you can determine the difference. My advice is tell everyone. As soon as you settle on dates, start giving notice as soon as possible to courts, coworkers, or other counsel, as well as clients, to avoid potential scheduling conflicts. Even if your trip's months away, you'd rather err on the side of more notice than not enough, though you may want to remind them of your absence as the date gets a little bit closer. Next, coordinate with your legal staff and fellow attorneys. Ask that your legal assistant be in the office when you're away. By having someone familiar with your cases in the office, you and your clients will have greater peace of mind that nothing will slip through the cracks while you're gone. And then review your bills. If your billing cycle falls around your vacation, make sure you review your bills ahead of time so they are mailed in accordance with the usual monthly schedule. Your client will likely be expecting a bill. And if you ever take APRO's billing webinar, you will hear me say over and over again that consistent billing procedures could be the difference between getting paid and not getting paid. Plus, it's one less thing that you'll need to add to your to-do list when you return. Also, calendar some breathing room. Be sure to timely mark out your vacation time on your calendar so nothing is scheduled on your anticipated days out of the office. Also, think about what will happen immediately before and after your return. If at all possible, set aside some time to plow through work and tie up loose ends before you leave. This includes both finishing up outstanding tasks and providing information to others so that they can complete work for you. The more organized your caseload is, the more you'll be able to enjoy your vacation. In terms of your return, avoid setting deadlines for the first 2 or 3 days that you're back in the office. You'll likely want to be catching up and reviewing what you've missed during this time, not rushing to meet a deadline immediately after returning. Also, it may be hard to relax on vacation knowing there's a hearing or a client meeting scheduled on the day you return to the office. So upon your return, think about reserving a day to catch up on email and voicemails. So next, set your away messages. Record a voicemail message advising of the dates that you will be out of the office and who can be contacted for immediate assistance. Likewise, setting an automatic email reply with the same information and instructions is an easy way to set expectations as to when your clients will hear from you upon your return from vacation. I usually write, I will have no access or limited access to email. I'm not going to be checking email here, so here's the person that you can contact in my absence. It might seem obvious, but a correctly worded out-of-office message can save you a number of stresses, namely from missed requests on urgent matters. This can also help maintain a client's faith in your ability to handle their case, cementing your reputation as a reliable lawyer. So craft a message that is relevant, informative, and polite, but also worded in a way that makes it clear that you're only available to respond to serious emergencies. And then always include an alternative contact for urgent matters. Also, as a solo practitioner, you may have a reciprocal arrangement with a colleague to cover each other's practices when you're out of town. Be sure to brief them on anything you anticipate might come up and let them know under what circumstances to reach you when you're gone. I can't stress enough that one of the keys to peace of mind on vacation is utilizing a vacation buddy. One important factor that should go without saying is that your vacation buddy should be someone you know very well and at least well enough to determine his or her trustworthiness and accountability. If you think that you'll spend your whole vacation worrying about whether a particular potential vacation buddy is staying on top of things, this is probably the wrong person for you. Equally important is to find a vacation buddy in your area of practice. Once you've selected a potential vacation buddy, be sure to be clear about what you need them to do. Are they checking your case online dockets or checking your email and scanning and emailing you anything that's urgent? Once your targeted vacation buddy has agreed to fulfill that role, decide how formal you both want the relationship to be, whether you want to put this in writing or not. This decision will be driven largely by what your vacation buddy will actually be doing and how long you are planning to be out of the office. If you only need your vacation buddy to check the online dockets for your cases informally, then you probably don't need a written arrangement. But on the other hand, if the coverage you're looking for is more involved and or of a fairly long duration, putting the specifics in writing will help prevent any misunderstandings about what the expectations are. I would also recommend mapping and strategizing your current cases. And what I mean by this is that it's beneficial to map out the potential timelines for your open cases and then create a case flow that's favorable to your vacation timeline. For example, if you have an opening brief that's due a couple of days into your vacation, based on your current workload, you may be in a position to file it before you leave. And while you will undoubtedly end up with a couple of late nights before any vacation, implementing these tips and strategies can give you peace of mind while enjoying your time off. And as with most things, striking that balance between going off the grid and being available, it depends on the lawyer and their practice. Some lawyers may be completely comfortable allowing their associates to handle their files in their absence. Others may struggle not to answer every email received while sitting on the beach. So think about what works best for you. And then that being said, it is possible to take time to relax and recharge while adhering to these ethical obligations that we just talked about. So with that, I'm going to pass the mic back over to Kate to talk about succession planning. Kate?
Thanks, Erin. Those are some great tips. Now, switching gears a bit, we want to dive into succession planning and the need to have a plan. Although none of us want to think about our death or potential incapacity, it is our professional responsibility to put some procedures or people in place to step in if necessary. For some practitioners, this may be a surrogate attorney. You'll see the rule on your screen which contemplates the designation of a surrogate attorney. A surrogate attorney is a successor attorney designated to take action to preserve and handle the law practice of the now deceased or incapacitated attorney. As states continue to develop their own rules with respect to surrogate counsel and succession planning, the ABA provides helpful guidance. Comment 5 to ABA Model Rule of Professional Conduct 1.3 states that the duty of diligence may require a sole practitioner to designate another attorney to review client files, notify clients, and determine the need for immediate protective action in the event of the death or disability of the sole practitioner. Practically speaking, the surrogate attorney should be someone who is familiar with your practice areas and that can competently step in and take over your cases for the short term, if not actually retained by your clients. The attorney should have the capacity and time to effectively run your practice or assist in winding it down. Oftentimes, this can be a reciprocal arrangement between practitioners. You will want to consider their age and how long they expect to practice as well to hopefully give your clients the continuity and representation they deserve. Having someone ready to take the reins for years to come not only gives your clients peace of mind, it is often cost-effective for them. You will also want to check for any conflicts to the extent you can. As you can imagine, states have different rules for succession planning. While designating a surrogate attorney is not yet required in every state, several jurisdictions mandate some form of succession planning. If we do not review your state's rules here, be sure to check your jurisdiction to ensure compliance. But I want to give a brief overview of some states' rules to give you a flavor of what's being required. As we look at the state laws, I'm proud to say as an Indiana barred attorney that the ABA identified Indiana's rule as the gold standard for attorney surrogate rules. The rule provides that at the time of completing annual registration, a lawyer may designate a surrogate attorney by specifying the attorney number of the surrogate and certifying that the surrogate has agreed to the designation in a writing in possession of both the lawyer and the surrogate. In Indiana, when the lawyer dies or becomes incapacitated, a verified petition is filed with the Supreme Court and served upon the designated attorney surrogate. The court may then appoint the attorney surrogate to continue the deceased or incapacitated lawyer's practice. Indiana's rule is quite comprehensive to the point of actually itemizing certain actions the surrogate attorney may take upon appointment, including taking possession of the files and records of the practice, applying for extensions of time, and notifying clients for purposes of the clients collecting their files and hiring replacement counsel. The rule further provides that the court granting the petition for appointment of surrogate counsel has jurisdiction over the closed files of the attorney and may issue orders with respect to the files, including for destruction, alleviating the potential headache of the surrogate attorney and perhaps the lawyer's heirs as they wind down the practice. The rule further provides that certain deadlines and statutes of limitations are automatically extended for 120 days from the date of the filing petition. I actually looked at the Southern District of Indiana website today, one of our federal courts, and saw that there are forms available, including a notice to the clerk where if you are the surrogate and you're providing that notice, you can state the reason for the unavailability of the subject lawyer. And in addition to the death and disability as reasons for their unavailability, disappearance and disbarment were also listed as justification for the surrogate to take over. So again, not circumstances any of us want to think about, but nice to know these safeguards are in place. I would expect other states to follow suit and establish these surrogacy processes, and some already have, so let's review those. Next on our list is Florida, and Florida is one state that mandates designation of a surrogate attorney. Through the state bar registration process, Florida attorneys designate an inventory attorney to take over if an attorney dies or becomes incapacitated. The rule provides that the inventory attorney does just that they inventory the files of the subject attorney and take such action as seems indicated to protect client interests. I want to point out California, which is not on our map here, but I feel like it sometimes gets a bad rap around the country, and we're hesitant to cite opinions, which are sometimes labeled as progressive. But when it comes to attorney surrogates and succession planning, it takes a very practical approach. The California State Bar has an attorney surrogacy program which provides a model agreement for the designation of an attorney to step in if a lawyer dies or is incapacitated. In fact, it provides a sample agreement which details the responsibilities of lawyers involved, titled Agreement to Close Practice in the Future for purposes of compliance with their Business and Professions Code and the Probate Code. Next on our list of this map is South Carolina. South Carolina requires its attorneys to prepare detailed succession plans specifying what steps must be taken in the event of their death or disability from practicing law. The rule contemplates the designation of a successor lawyer and even provides that the designation plan may set out a fee-sharing arrangement for the successor attorney. Next, Illinois requires active practicing attorneys to state in their annual registration whether their organization has a written succession plan. However, it does not require that a plan exist. In New York, the New York Rule of Professional Conduct regarding diligence, Rule 1.3 and its Comment 5, mirrors the ABA rule in stating that to avoid possible prejudice to client interest, a sole practitioner is well advised to prepare a plan that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there's a need for immediate protective action. While designation of a successor attorney is not required, it is certainly recommended. Finally, Texas. The Texas State Bar urges its attorneys to develop succession plans and even designate a custodian attorney in advance. Texas practitioners can use the State Bar portal to designate the custodian attorney. This attorney does not inherit the lawyer's law practice, but it is anticipated they will serve in a more limited role to wind down the practice. Texas likewise provides, upon notice of the unexpected death of a busy sole practitioner in the absence of any succession plan, that the Office of Chief Disciplinary Counsel or another interested person may petition the court to assume jurisdiction of the lawyer's practice. Pursuant to the rules, the court will appoint a Texas attorney to serve as custodian attorney. In reviewing just a few of these state rules concerning successor attorneys and succession planning, you can see how different states have addressed the issue. And again, in the busy day-to-day work of a law firm, succession planning may not be top of mind, but it's certainly something to start thinking about. But if you haven't, you aren't alone. According to a 2018 Thomson Reuters survey of the U.S. mid-sized law firms, the legal industry is lagging far behind in terms of leadership and firm succession preparedness. In fact, only 40% of firms surveyed said they felt prepared to deal with their retirement and succession of partners, while 61% said they were concerned about their lack of preparedness. In addition, only 37% of surveyed firms said they had a formal succession planning process in place or were in the process of creating one. The remaining 43% had an informal process or didn't even have succession planning on their radar. Ida Abbott, president of Ida Abbott Consulting and a fellow with the American Bar Foundation, says the succession planning issue is becoming really urgent because we know that about a third of equity partners are at retirement age. You're looking at the potential for a major outflux. Even firms without mandatory retirement run into a lot of problems because lawyers tend to not believe it's actually going to happen to them, and they delay talking about it or doing anything about it until the issue is right in front of them. So again, just looking at these statistics, if you do not have a plan yet, you aren't the only one. I would encourage you to start with the ABA materials on succession planning. You'll find state-specific resources as well as their recommendations for a comprehensive succession plan, which should include at a minimum written instructions concerning how and where client information is stored, such as bank and other account details, instructions concerning disposition of closed client files, and information about law office equipment, leases, and other contracts, information concerning the payment of current liabilities, and even instructions as to how to gain access to computer and voicemail passwords. Next, let's turn to some practical ways to set up your surrogate for success. Quite simply, effectively and efficiently running your practice is the best way to prepare your surrogate attorney in the event they need to step in. Regardless of the size of your practice, implementing and documenting consistent office procedures and protocols is paramount. By developing a manual or simple training materials that clearly communicate how to use the firm's calendaring system, the conflicts check procedure, and accounting systems or billing software, the surrogate attorney should be able to seamlessly transition into your practice. Perhaps the most important means to ensure a smooth transition is maintaining an active file list and calendar. The surrogate attorney's first order of business will likely be reviewing your file list and cross-checking it against the calendar to ensure no court deadlines or dates are missed. Assistants and paralegals may assist with keeping you organized on a day-to-day basis, but they should also be well equipped to assist the surrogate attorney. Quite frankly, your practice, and maybe even your estate, is at risk if your files are poorly documented or incomplete. Make sure to develop and implement best practices in terms of organization now for yourself and your designated surrogate attorney. With respect to communication, the fee agreement is an effective means to advise clients who they may contact in the event of your death or incapacity. Consider adding a provision to your fee agreement with the surrogate attorney's name and contact information. Most clients will appreciate the proactive steps you've taken in protecting their interests should you be unable to continue to represent them. And invite the conversation about this as well. Explain that they will have the option of selecting another attorney, and if they want to use the surrogate attorney you have identified, the surrogate will have to perform a conflicts check. In other words, by signing the fee agreement, they aren't agreeing to be represented by someone else. It's more for their convenience and to ensure their case does not inadvertently fall through the cracks if you unexpectedly die or are unavailable. I'm now going to turn it over to Erin to talk about retirement.
Great. Thanks so much, Kate, and great tips. So as Kate said, we're going to shift gears a little bit and talk about retirement. And it's a good question to think about. Why is closing down a law practice any different than closing down any other business? Well, as a lawyer, we have more ethical considerations than any other profession. So that's why, and we went through some of those ethics rules already today. So what needs to be done? I have some resources here on the slide, and I recommend that if you are planning to retire, to certainly look at them, but also contact your local bar for additional resources. Again, on your slide, you'll see I have the Florida Bar has a great checklist for lawyer retirement. But I would also say Kate and I have spent a lot of time this year putting some resources together for our insured lawyers on our website, because this is a question we get asked a lot about. I'm planning to retire. What do I need to do? So if you are looking for resources, you can go to our website because we've kind of consolidated all of these great resources in one place. And under Protect Your Practice, you'll see things for how will your firm survive this silver tsunami. We talk about vacation, retirement, succession planning. There's a lot of checklists there. So another resource is to go to our website. But the first thing you want to do from a practical standpoint is stop accepting new cases. Even before you begin the process of winding down your law practice, stop accepting new cases. Each new client you consult could become a potential conflict when you do close your law firm. Speak to other attorneys about referrals. Referring cases out could garner some income even as you begin closing your firm. And then set a date. Closing a law practice does not happen overnight. It will likely require action over several months. So pick a date based on your active case files and their already scheduled deadlines, and your ability to secure permission to withdraw while trying your best to set the client up for a successful transition. This is a lot easier said than done. So I recommend mapping out a retirement timeline. This will give you an idea of what your rough time frame for retiring might be. Start by compiling a detailed list of all your open cases. Next, estimate a timeline for finishing the remaining work on each case. You may want to do a range for each case. Figure out what the timing would look like if the case moved at the average rate of your other or similar cases, as well as figure out timing if it moves more slowly than is typical. Once you've done this for all of your open cases, you'll have an idea of when approximately you would first be in a position to retire from the practice of law. You may find that your first opportunity to retire based on your current caseload is sooner than you expected or wanted. Another possible outcome of mapping your timeline to retirement is that you find it's a little bit further out than you had hoped. Once you're able to pick a future date, next begins the process of closing your law firm one step at a time. Inform clients and other key professionals. Once you've set a date, it's time to start informing clients that you're closing your legal practice. Contact your long-term clients, discuss any pending cases and their options such as new counsel, attorney fees due, or refund of fees if you are not going to be able to complete work when the payment's already been received from the client. From a risk management perspective, it's important to document all proper communication to clients advising that your firm is closing, because being able to produce clear documentation about when and how you told clients about your firm closure, it will help if clients fail to take these steps to protect their own interests. Attorney closure letters should be used to convey the proper steps clients should take surrounding the law firm's impending closure. I recommend looking at a sample dissolution letter and then tailor it to your own needs. These can be found on your state or local bar association's websites. There are many good examples of law dissolution letters, such as the next slide that we'll show. It has a version from the South Carolina bar. But at a minimum, your letter should inform the client of your legal practice's closure date, the status of your client's case with you, how you'll handle the transfer of your client's files, and if you hold funds in a trust for a client, your law firm closing letter should also discuss the amounts and how refunds will be handled. Conclude active cases or position for smooth transition. Ascertain the status of client files. Each open file needs to be considered with regard to its deadlines and its fee arrangements. Remember, if the file is being either given to the client or the client's new attorney to stress in writing time is of the essence. In cases where the client's obtaining new counsel, be certain a substitution of attorney is filed. Once clients are informed, start packaging their files for transmission. You should have two goals when packaging a file. One, make it easy for the client or their future lawyer to continue pursuing their interest. And then two, be sure to remove any document of value from your archive. Kate's going to talk about this in just a bit, so I'm not going to steal her thunder here, but client items with intrinsic value should never be destroyed. And then be sure and retain a copy of the file and written acknowledgement from the client or new attorney that the file has been transferred. After obtaining the client's consent, file a motion or order to withdraw from any pending litigation. Next, return closed files and original documents. A retiring attorney is likely to have boxes and boxes of closed case or client files. Kate and I get asked on our risk management hotline all the time, how long do I need to keep a closed case file? The answer is different states have different requirements, and Kate's actually going to cover this in a bit as well, so I'll hold off on talking more about that. You also want to think about terminating leases and rental agreements. We talked earlier about the benefits of mapping out a timeline to retirement, but mapping out a timeline also helps provide a time frame to manage the renewal of practice-related contracts, such as office space leases or your Westlaw LexisNexis contracts or your telephone contracts, even your domain name rental, your website hosting, all of these things. These renewal dates should be added to your timeline because you'll need to reach out to your landlord and vendors to finalize arrangements. You'll need to terminate your lease for your office space. You'll also terminate your equipment leases and make arrangements for the removal of these items. For any contract that will extend beyond the close of your practice, you may need to negotiate an early termination or see if you can switch to a month-to-month plan. Also, be aware of practice-related contracts that are tied to your credit card and renew automatically. Utilities and services need to be canceled. You need to cancel office subscriptions and other memberships. So it's a good idea to extend some contracts, such as those for business email or your website or even your business telephone, so that you can provide notice of your retirement as well as how to contact you regarding a closed case. So consider letting these outgoing messages run for several months after you've closed your practice. And if you have a website, you might consider reducing it just to one page, which is enough to inform those visiting your site of your retirement and their options. And then close trust account and notify the state bar of your retirement. Close your trust accounts and notify the state bar associations and also any other professional organizations of your change in status. Part of submitting your notice for retirement includes updating your status in the attorney information system. You can change your status from active to retired, but if you think you may practice again in the future, you can also change it to inactive. But this is definitely something you're going to want to address as well. And as always, check in with your local bar association about the requirements and then notify any insurance carriers about your retirement. So as well, I said notify the insurance carriers. The risk covered by malpractice insurance does not go away just because your law firm is closed. Discovery periods and statute of limitations for malpractice claims will continue long after your law firm closure. A lawyer leaving the legal profession should contact their insurer to discuss continuing coverage even after the closure of the law firm or the addition of an ERA, which is an extended reporting endorsement or tail coverage, you might know it as, to the policy prior to closing the firm. And I'm going to talk about this in more detail if you're not familiar with an ERA or tail coverage at the end of the presentation when we talk about insurance considerations. So we'll talk about that in a little more detail in just a bit. But walking away from a law practice, it's not as easy as turning off the lights and locking the door. It does take a bit of planning, and the more organized your office is, the simpler all of these steps are going to be. So next, we're going to talk about communication and notifying the client. You'll also see on the next slide, there is a sample letter that I referenced earlier about notifying the client on your retirement. So if you are looking for a template, I think that this one from the South Carolina Bar is a really good one. Okay, so buying a law practice from a retired lawyer. We wanted this webinar to help lawyers thinking about retirement, but we also wanted to share some tips for those lawyers that are still looking to grow their practice. A lot of lawyers are retiring right now, so this is a great opportunity for some younger lawyers to expand their practice. Whether you've started a law practice and you're looking to expand or are thinking about leaving a large firm and venturing out on your own, buying a law practice may be right for you. Regardless of where you are in your career, it can be much easier and most likely more cost-effective to buy a law firm than it is to start one on your own. Many attorneys do not even consider purchasing a law firm practice because they don't realize they can, or they don't know where to start with the process. So, where to find law practices for sale? Unlike real estate, you're not going to find a for sale sign outside of a law firm, even when the owner of the firm wants to sell their practice. So how do you find a firm that you can purchase? One organic path is to network with older attorneys who may be looking toward a transition soon. You can also look at registries created for this niche, such as private practice transitions, that's one. Biz Buy Sell is another one. Some registries even provide support by making experts available to answer any questions that you have regarding buying a law firm. As always, reach out to your state bar associations. These are always great resources. State bar associations can be really valuable, and they can also help guide and support lawyers when choosing which firm to buy or how much to even pay for it. For example, I know the Washington State Bar offers a career center that you can filter to show practice transition. So you might want to check this out if you're interested in buying a firm. And with this filter, I know you can find attorneys who are potentially retiring or looking for buyers. So just something to think about. But if you are thinking about buying a firm, you definitely want to consider the area of practice, the client base, and branding. So, of course, you don't want to buy a commercial law firm if your area of practice is personal injury. To ensure that you target the firms that most align with your experience and goals, you need to first consider your long-term goals. What type of attorney do you want to be? Where do you want your practice to go? What area of practice or areas of law do you want to practice in? It's also important to review the existing clients of the firm for sale to gain an understanding of the needs being met and whether those clients seem like ones with whom you would have good chemistry. Of course, you need to do your due diligence. You should review financials, tax returns, and cash flow projections, and meet with the owners and key staff. While making the decision to purchase a firm is an important first step, due diligence will be the most time-consuming one. So when conducting your due diligence, you should engage a financial advisor to address whether and how the purchase of the firm will help you with your long-term financial goals, your CPA to advise on tax benefits of purchasing a law firm, and an advisor who can help you with the deal structure. There are also ethical considerations to buying a law practice. You would want to review Rule 1.17, the sale of law practice, which states that the law firm seller must make clients of the prospective firm aware of the sale and have the right to choose another counsel. Most states have similar requirements, but the rules of buying firms can vary between jurisdictions, so make sure you check yours before buying a law practice. You would want to create a transition plan as well. After the sale, there will be a transition period. And during this phase, the seller should transfer the knowledge base, key clientele, referral networks, and other elements to give you the best chance of success in your new firm. I would also just say, if you're looking for more resources regarding buying a new firm, we do have some more on our AppPro website as well. So again, if you're looking for more information on this, that's just another resource to look at. And with that, I'm going to hand it back over to Kate to talk about closing your practice. Kate?
Great. Thanks, Erin. We're now going to touch on some topics related to closing your practice. We'll first jump into file retention and destruction, look at dissolution and tax considerations, and see what the rules of professional conduct require concerning trust accounting and record keeping. With respect to file retention and destruction, these are difficult for many lawyers and law firms. We receive, as Erin mentioned, many inquiries on our risk management hotline concerning file retention. And quite frankly, I think most of us would admit we have trouble letting go of old files despite rarely, if ever, referencing them. There's just something about giving the okay to shred it that gives us pause for fear of violating the rules related to file retention and destruction, or thinking we're going to need something the minute we approve the file's destruction. Of course, when selling or closing your practice, there are practical considerations of file storage or wanting to avoid transferring an abundance of old files to another attorney. So where do you start? First, follow your policy. And understandably, for an older, closed file, you may have forgotten the file retention policy agreed to in the engagement letter, and hopefully reiterated in your closing letter. Check this correspondence when you pull the file to determine whether you need to retain the file and transfer it or destroy it. If destruction would be appropriate, see if you previously agreed to provide notice and opportunity for your client to retrieve their file prior to your destruction. You can include a destruction notice in your letter about closing your practice, which may prompt your client to pick up their file, which alleviates the need to further question whether you may need to possibly transfer it. In the sample retirement letter that Erin spoke about, you'll also find language concerning file retention and destruction. Now, if you don't have a firm policy for file retention or destruction, you'll be happy to hear that the ABA model rules offer some helpful guidance concerning a lawyer's obligation to maintain client information to fulfill their ethical duties. Model Rule 1.16D provides that upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client interest, such as surrendering papers and property to which the client is entitled. While not a hard and fast rule for a number of years the file must be retained, this is instructive. First, it does not require a firm to keep all files indefinitely. And secondly, it contemplates the possibility of returning the file to the client while at the same time clearing out old files. Of course, this comes into play when you're in the process of closing your firm. If nothing else, it should give you some assurance that you do not need to stack old client files in your garage and that you can comply with the rule by reaching out to clients to pick up their file if you don't have a policy. Now, if your client doesn't get back to you about picking up their file, run through a quick checklist before sending the file to the shredder. First, ask what documents are in the file. Original documents such as wills, deeds, and certain contracts should be maintained, and their destruction will likely need to be evaluated on a case-by-case basis. Some states will dictate a minimum number of years to retain the document, but you should also consider the lifespan of the document as well. If the contract term has not expired, it would be premature to dispose the document. And if you're not transferring this file, you may want to hold on to it. Next, see if there's any pending litigation. Perhaps one box to check before destroying a file should be whether a litigation hold exists. If you received a litigation hold letter, you should check the status of the litigation or any government investigation before evaluating the file for destruction. Maintain the file in its entirety or transfer it because violation of a litigation hold could have serious evidentiary consequences for your client. And finally, what is the statute of limitations for legal malpractice in your state? Check your state's statute of limitations for legal malpractice claims as the minimum length to retain the file. Your entire file, including all of your notes and draft documents, may be your best defense in a malpractice action. Now, how do individual states address client file retention? Not surprisingly, individual states and their bar associations have different opinions when it comes to file retention. Although California courts have not yet addressed the retention period, several California bar associations have provided guidance. For example, the Los Angeles County Bar Association opines that a civil attorney should retain potentially significant papers and property in the former client's file for at least 5 years. This is consistent with a California rule of professional conduct, which requires an attorney to maintain all records of client funds and other properties that the client provided to the attorney for at least 5 years. In Alabama, an Alabama State Bar Association advisory opinion provides that a lawyer should maintain a copy of the client's file for a minimum of 6 years from the termination of the representation or conclusion of the matter. The opinion cautions that 6 years is the absolute minimum period, and in certain circumstances may require a longer or even indefinite period of retention. Such circumstances could include files related to minors, probate matters, taxes, and transactional matters, which require lawyers to maintain a file until its contents are rendered obsolete by the passage of time and serve no useful purpose to the client or lawyer. The general rule for file retention in Illinois is 7 years. Illinois Supreme Court Rule 769 provides that all financial records related to the attorney's practice, including bank statements, time and billing records, checks, journals, financial statements, and tax returns, among other financial documents, must be maintained in a physical or electronic file for at least 7 years. While the rule does not encompass all potential components of a client file, most Illinois attorneys allow 7 years to pass before considering whether they must retain or can destroy the file. While state legislatures and bar associations perhaps do not offer the bright line rules we would like, they do provide helpful guidance to practitioners wanting to clear their file cabinets of old client files, especially when shutting down their practice. As a rule of thumb, consider the time frames provided by your jurisdiction as the minimum length of time to keep a client file. Then exercise good judgment when considering questions of file retention. Best to err on the side of caution and keep the file physically intact or transfer it to the attorney taking over to or maintain an electronic copy if your client does not retrieve it. Now, what does the ABA say about file retention? In addition to the model rule I just mentioned, the ABA has offered further guidance in Informal Opinion 1384 to attorneys deciding how long to maintain former client files. And given our time constraints, I'm just going to reference that opinion. You may want to check that out, but I do want to move on to the dissolution and tax implication question, so we get some time on that. So you've decided to close your practice. Does this mean you dissolve it? As I alluded to in the prior section, closing your practice could also involve selling it to another attorney or firm. So while a complete dissolution may be appropriate for some, you may have other options to explore, whether it be a buyout, acquisition, or merger. If dissolution is the right path to take, follow the dissolution procedure in your partnership agreement. If you're a sole practitioner, create a checklist to follow, including canceling any active marketing or advertising, collecting money owed to the firm. And depending on where things stand with your receivables, you may need to explore collection options with an outside firm or vendor. Be sure to settle any creditor claims, notify your landlord and insurance carriers, and consult with your accountant to assist. You'll likely be working with them closely throughout the winding down process. And of course, file the necessary dissolution paperwork with your state. Of course, the most important component of dissolution is notifying your clients, as we've discussed. The attorney-client relationship distinguishes closing a law firm from shutting down other businesses, as we have certain ethical obligations to meet. We must communicate with the client, deal with client trust accounts appropriately, and remain diligent as the deadline to close the firm nears. Be mindful of the timing for your clients. You need to give them reasonable notice that you're terminating representation in light of the firm closing so they can retain other counsel and you can assist in transferring their file or returning their file and property to them. You'll need to refund any retainers for fees that you have not earned or for expenses not yet incurred. And keep complete records of client account funds and property for 5 years after ending the representation. A quick note with regard to taxes. Again, be sure to work with your accountant to tie up all loose ends. However, note that in general, the IRS advises dissolving firms to file an annual return for the year you dissolve your firm. For partnerships, you must indicate it's your filed tax return. File employment tax returns, make final federal tax deposits, issue final withholding information and wages to employees, report capital gains, losses, partner shares, W-2, and 1099 information, and report the corporate dissolution. Next, with regard to trust account record keeping, I just mentioned keeping complete records of account funds and property for 5 years after the representation ends. This slide shows the complete model rule of professional conduct, but as always, be sure to check your state's rule and treat 5 years as the minimum deadline. And in terms of the practical guidance that we can offer, remember that law firm dissolutions take a tremendous toll on those involved, partners, associates, staff, and your accountant. The focus tends to be on the winding down of business affairs, but the primary obligation should be to the law firm's primary asset, its clients. The lawyer-client relationship creates a fiduciary duty that does not abruptly end when a law firm decides to dissolve. That duty requires a high degree of fidelity, good faith, full and fair disclosure, and maintenance of confidentiality until the winding down of the business is complete and all legal matters are properly concluded. I'm going to shoot it back to Erin to now discuss insurance considerations when closing your practice.
Great. Thanks so much, Kate. Now to the fun stuff, insurance considerations to closing your practice. For those who don't have a legal malpractice policy or maybe never read their policy, professional liability policies afford coverage for 1 year at a time. So in order for an attorney to have coverage in place at all times, a policy must be obtained every year. Continuity of coverage is really important in a claims-made coverage, and when an attorney changes firms, becomes a judge, retires, or exit private practice for any reason, an ERE becomes available and necessary. And I had referenced this earlier in the presentation, but an ERE is an extended reporting endorsement, and it's also known as a tail coverage, so you might have heard of it under that name. This is needed because of the claims-made nature of a lawyer's professional liability insurance policy. A claims-made policy provides coverage for an alleged action that occurred during the time the policy was in effect. In other words, the coverage provided in a claims-made policy ends when the coverage terminates. So your ERE, it's not a separate policy. Instead, the endorsement extends the terms and conditions of the prior existing policy and allows an additional period of time for a claim to be reported to the carrier. So in other words, it allows you to report claims to the insurer after the policy has expired or been canceled. This means no coverage will be available for a negligent act or omission which occurs during the time the ERE is in effect. So if you're doing pro bono work for a friend after you retire, this is not covered under the endorsement. If you think you need an ERE or you have more questions, feel free to contact APRO, or again, go on our website. It explains what all these fun insurance terms are. Or if you're looking for more information, certainly contact your current broker. But if you are trying to understand what the ERE is or tail coverage, if you're thinking about retiring, please go to our website and you'll find more resources there. But to wrap this up, because I know we have 1 minute until this webinar is over and we open up the Q&A, just think the risk covered by malpractice insurance, it doesn't go away just because your law firm's closed. Discovery periods and statutes of limitations for malpractice claims will continue long after your law firm closure. So a lawyer leaving the legal profession should contact their insurer to discuss continuing coverage and the addition of an ERE to their policy prior to closing the law firm. And with that, I'm going to hand it back over to Michelle to open up our Q&A. Michelle?
Thanks so much, Erin. Great information to Erin and Kate. The first question that I'm going to ask Erin to repeat the resources referenced for buying a law firm. We've had quite a few requests for that.
Oh, yeah, absolutely. So we talked about where to find law practices for sale. There's a couple of sites you can look at. The most popular one is probably that I know of is Biz Buy Sell, and Biz is B-I-Z. Biz Buy Sell. Private Practice Transitions is another one. Law malpractice exchange, I believe it is another one. But really a great resource would be look at your state bar associations. I think during the presentation I mentioned the Washington State Bar. They have a career center, and you can actually filter your search to show practice transitions. And in there, you can see attorneys that are potentially retiring or looking for buyers of their firm. The Oregon State Bar, they have a forum where members, they can post to inquire about firms for sale too. So I would say another great resource is going to be your local bar as well.
Perfect. Thanks, Erin. Okay, a couple other questions that came in. If a sole practitioner designates a surrogate, how can either be sure that there will not be a conflict in future cases? It is impractical to constantly check conflicts, and to do so would constrain the practices of both.
I'll take this one, Erin. And this is a good question, and I think their answer is you can't really be sure. And ultimately, it's something that your surrogate will handle if they have to step in. Although we have an ongoing duty to monitor our cases for conflicts, I don't think this is necessary when you identify the surrogate. I mean, you may run through your file list and kind of talk about things generally before you agree to the relationship, but I think as cases are coming in, as you're monitoring your cases for developments of conflicts, you don't have to check that with your surrogate. But, you know, you're likely choosing someone in your practice area where conflicts could exist. But quite frankly, you know, you're going to be letting them address those should they need to take over.
Here's another one. If a lawyer retires, are they still subject to disciplinary action when retired?
Yeah, I can take this one, Kate, just because I covered this a little bit when I was talking about retirement. But yes, they are. If you think about it, you might make a mistake today, retire tomorrow, and then the client might not learn of the error or the wrongdoing until after you retire. And that's why there's statute of limitations for bringing a malpractice claim. When I talked about attorneys retiring, I talked about the extended reporting endorsement, which is the ERE or tail coverage, and I talked about why that is necessary, right? So this endorsement extends the terms and conditions of the prior existing policy, allowing for that additional period of time for a claim to be reported to the carrier. So in other words, it's allowing you, after you retire, to report claims to the insurer. So this is why it's so important. Like I said, if you're thinking about retiring, a really important consideration is going to be thinking about the applicable discovery periods and statute of limitations for malpractice claims. Because even after you retire, like I said, the client might not know about the wrongdoing until after you retire, and that's why you want to make sure you have coverage for that and that your ERE is appropriate. So that's my advice. Yeah.
Great. Thanks, Erin. Another question, is it required or recommended to explain reason for being out of the office, for example, vacation versus medical issues or other personal matters for that fact?
I'll take this one, Erin. You talked about this a little bit. I've actually never seen any requirements about this. I think it's up to you and depends why you're out. It depends on the nature of your practice. You may want to mention you're on vacation in your away message. Then that gives the client an idea when you'll return. And you can be as specific as possible in that message. They may be less likely to bother you, too, if you tell them you're on vacation. As far as a medical leave, I don't think you ever have to disclose those specifics. But, you know, you may have clients that you're in nearly daily communication with or have ongoing matters, and you may want to give them a call and give them a heads up that you'll be out for surgery or something of that nature. Regardless of why you're out, I think it's always nice to instruct your assistant as to what you want to communicate, or just put it in your away message and be sure to note who they can contact in your absence, and then let that attorney know under what circumstances they can contact you.
Thank you, Kate. And let's see, one last question. If a legal assistant replies to an email, do they need to disclose that they are the one responding and are not the attorney, even if they're not providing any legal advice?
I can take this one, Kate. Kind of to begin, just like Kate's last answer, it's not required. I haven't seen any requirements on that, but I would advise that you inform your client that your assistant's going to be checking your emails while you're on vacation or for whatever your absence is, but then sending you anything urgent or requires an answer to a legal question, not something just administrative. So I think personally this gives them a level of comfort knowing that if there is any burning legal question that you'll be able to answer it or your assistant will pass it along. I think we also talked about earlier just tempering client expectations, and I think this is another good way to do that.
At this point, we are out of time for further questions, and this will conclude today's event. On behalf of Attorney Protective, I would like to thank you all for joining us for today's webinar. Special thanks to our speakers, Erin and Kate. Have a wonderful day, everyone.